All right, everybody. Good morning. Good morning, everyone. I am here in Atlanta, Georgia. I see we have somebody from Michigan. That is awesome. That is awesome. For those of you who I know, welcome back. Good to see you. Well, you can see me. I can't see you. For those of you who I don't know, thank you for joining me. I really appreciate it. I hope that the next hour or so is useful in terms of you spending your time with me. My goal in setting expectations here, I'm going to keep them very low. It is to tell you one thing, just one thing that you can take away and improve your practice. If I tell you 2 or 3, that's awesome. My goal is 1, set low expectations. That's the first rule of damages. Last week, if you weren't able to join us, we covered some of the early parts in a case and how that relates to damages. For example, we covered writing persuasive demands. We covered offers of judgment and settlement a little differently, I think, than a lot of people do. We talked about leverage and how to create that, jury research and the folks at Case Metrics, and using medical videos and illustrations. So today, I want to talk more about as we get further in the case through depositions and then into the trial. So I think today's going to be really fun. As I was thinking about putting on what I was going to talk to you about today and what I was going to put on in my materials and thinking about how last week went, I kept coming up with bad ideas. I kept coming up with all of these bad ideas that I've had over the years. And what I realized and what I want to start by telling y'all is these ideas are not all going to work. They are not all going to work. Some of them are going to work amazingly in one case, and then they're going to fail in another. You're going to probably get discouraged. I've gotten discouraged because I thought I had something down and then it didn't work. What I would encourage you to do is to make a list of every way that you can prove or increase your damages and consult that list every single time that you are trying to accomplish that. There are going to be things on the list that work. There are going to be things on the list that don't. The list of things that haven't worked for me is very, very long. Lewis Cohen is in here. He's, like I said, I think before I started, one of the best marketers, if not the best marketer and networker I know. I would love to hear, Lewis, if you want to do a webinar, I would love to hear the ways that he has tried to increase and grow his business in the way that it hasn't worked. One day I'll give you my list. It's really long. The same goes with damages. So you're going to have ways that you think are foolproof that will fail, and you're going to have ways that you think aren't going to work, but might as well try, and it's going to go great. So try your best, be creative and think, and just try one way at a time. Some of this might be overwhelming. When I go to other people's CLEs and watch webinars and read books, I get really overwhelmed at all the different things. Oh, this person's doing this, this, and this. Well, I would encourage you just do one thing. And then if that works or doesn't, go to another thing. So let me help you build your list. And the first thing we're going to start with is experts. It's something I didn't cover last week. I could spend hours on experts. I'm going to touch some of the high points and give you some things to think about, okay? The first thing that comes to my mind when I think of an expert is actually an in-house expert, and that's a nurse. If you are going to prove medical damages, I think it's helpful to either have a nurse in-house part-time, full-time if you can. We don't have somebody full-time. Or use somebody I see on the chat, somebody like Sean, who's a legal nurse consultant. My legal nurse consultants do 4 things. And I use one person, have been using this person for years. Sean, you're not going to get any business from me. You can market to everybody on this email list though, or everybody on this webinar. So the first thing I want the nurse to do is give me a chronology. Even though I'm going to read every single medical record and every single medical bill myself, I want the nurse to give me a chronology of every single date and what the heck happened. And when there are terms that I might not know, I want the nurse to tell me what they are. The second thing I want is a bill list. I want to know every single date of service from every provider and how much the bills are. I don't want to be overcounting. I don't want to be undercounting. I want to know the bills to the cent. I think that gives you a lot of credibility. and I want my numbers internally to match the numbers of the nurse. So I'm doing twice the work. Third thing, I want what I call a needs list. It's a needs list. A needs list tells me what I'm missing and what I need to go get. So, easy example, sometimes radiologists' bills are separate than the bills for the main provider. Radiologists have their own practices a lot of times. Same with anesthesiologists, same with a lot of other providers. I want the nurse to say to me, hey, Mike, there's a radiologist here. You don't have that bill. Go get it. In the end, the nurse is going to be paying for himself or herself because the nurse is going to tell me about more bills and more damages. I can go get those. And then the nurse essentially pays, is free. I mean, it's a great idea. In terms of records, same thing. I want the nurse to tell me, hey, there's a note in page 5 from this provider that mentions this other provider. You might need to go and get those Grady records. I know the client was at Atlanta Medical Center, but you need to go to Grady and get those records too. So it's a foolproof way to do this because you have an expert on your team. And 99% of the time, I think the expert pays for themselves. Fourth thing a nurse can do is write a summary that you can use to varying degrees for your demands. So depending on the injury, depending on the facts, the nurse can give you a summary of the injuries so that you can put it in your demand. I am a grammar Nazi. So the nurse that we use writes in passive voice. So it doesn't work for me all the time. The nurse also doesn't understand, and rightfully so, doesn't always understand the legal principles and why stressing some things is important and stressing others isn't. And that's fine. So I don't recommend just blindly putting a summary written by anybody else in your demands or using it, but that is a fourth option. So we've done all 4 of those things, and in the end, it has increased the value of our cases and helped us explain to the jury or whoever the audience is what we're trying to accomplish and what the injuries were. Tim asked, for those who haven't used a nurse consultant, what's the fee for them to go over records? Usually it's an hourly rate, Tim, and I think that depending on who you use, depending on what you're asking them to do, depending on their expertise, all those great factors, that the price can change. But in my experience, the nurses are paying for themselves. I'll also add a fifth thing that I have seen done, I would love to have done, but we don't currently use a nurse to do it, which is have the medical records and bills organized chronologically by provider. So I know and I've used somebody who's not a nurse to do this, but I've taken, let's say we have 15 providers, send them to somebody, and then have them put them in a combined PDF bookmarked by provider. Same with bills, bookmarked by provider. So that way it's very easy for us to send those records, very easy for us to review them. And then ultimately at trial, it's really easy to print them off and stick labels on them. And you have your exhibits for your medical records and bills in order already. I don't want to be, 2, 3, 4 weeks before the trial and trying to figure out, can I get all my medical records and bills in order? I'm also looking for certifications to make sure that the certifications are good. All right, the next type of expert that I would recommend, especially when you have a permanent injury, you need an expert, which can be a treating physician or a non-treating physician, to do an impairment rating. So impairment ratings, typically, you're getting 2 impairment ratings. If I hurt my shoulder, I will have an impairment rating for my shoulder or arm. I will also have an impairment rating for my entire body. Because if I lose X percent of my shoulder, that affects a larger percent for my whole arm, my upper extremity. And it affects a big portion of my body, but it's a less percent. So I'm going to have at least 2 impairment ratings for permanent injury cases. They're going to be the local rating and also the whole body rating. You can find folks like this all over the earth. They're apparently not in the chat today, unless they'd be blowing it up. But you can certainly have a number of people do this. I would recommend that this person read all the medical records, that this person be able to meet the client. So these are things that you want to think about in a permanent injury case. You probably need to have the client, you almost certainly need to have the client at maximum medical improvement. The client needs to be as good as they're going to get in order for the impairment rating to really matter in the long run. If your client is impaired, most likely the client's job is affected. So you might consider a vocational expert. And this is a person who would meet your client, learn about your client, learn the things that the client can and can't do, learn about their education, their training, learn everything that they can about the client. Essentially, they're interviewing the client, seeing what kind of jobs that they can fulfill. Then that vocational expert's going to get a job summary. You're going to get the job summary from the client's employer. You're going to want to get all the benefits that the client has, all the job duties, all the work hours, everything you can from the employer. So you're going to send a non-party request to your client's employer or a subpoena asking for all the documents that you need. You're going to give them to the vocational expert. And the vocational expert's going to compare what the client is able to do, both physically, based on their training and expertise and education, and compare that to the job function. So we had a case recently where a client worked at a warehouse. He was a warehouse supervisor, and he wasn't able to do that anymore. So the client, we set the client up with, well, after getting all the client's records from his job and the job, you want to get the job duties. You also want to get any applications for the job and any advertisements that the company has sent out. And you want to give them to the vocational expert. In this case, the vocational expert reviewed those. And the vocational expert said, I don't think he can do the job. You know, the client had minimum education, formal education. He's really good at this job that he had. He rose the ranks as a supervisor, but he's not physically able to do it anymore. Now, the pushback we got in that case was, it's the classic, he can do it. He can do it. Well, so what we decided to do was we crafted a letter along with the client that was a cover letter for a job application. Because the client was out of work. The employer let him go, said you're not able to do it, you're too big of a risk. So we've got our client and an expert saying, I can't do the job. And we've got the defense saying, yeah, you can. So what we did, show you this. What we did was there we go. All right, what we did was we decided that we were going to create the client, and the client, I mean, in the end, did this himself. We're going to have the client create a cover letter and create a resume and apply to a ton of jobs. So you can see right here in the date modified column, and I apologize, I can't make this larger. From November 20 of last year through January 20, so 2 months, we applied down here in the left corner to over 50 jobs. And these were all jobs that were in his alley, that were in his wheelhouse. And what we did in the application was he filled out the application. I mean, he put everything he needed to, but he included a cover letter that we had written with him and in conjunction with his doctors. And it listed the physical limitations he had. And it was a letter that said, I really want to work, which he did, and he does. And I really want to work for your company. I lost my job because the employer said that I wasn't able to physically do it. I wasn't fired for any other reason. I'm a really hard worker. I do have some physical limitations. Here's what they are. I want to be upfront and honest with you about them. And as a result, here's what I can handle. Please hire me. I'll do anything I can. You might not be surprised to learn that 50 plus job applications later, he didn't get a single interview. We then sent this combined file, this application file, to the defense and said, along with the letter, so you're writing the letter not just for the employer, you're also writing the letter for the defense lawyers, the insurance company, and ultimately the jury, and the applications and the resume. And we said, look, you say he can apply for jobs and get jobs. We've been trying. We've been trying. So that's one of those ways. It's the first time we've ever done that. But that's one of those things that I don't know if it'll ever work in the end. I think it did. It served its purpose in this case. And we were proud of the results. We actually mediated it virtually a couple weeks ago and got the case done. So I think that and it was a second mediation. We mediated a couple months ago. I think that I don't know how much it mattered, but it's certainly something that we were able to push back and say, oh yeah, you say he can get a job where? Where? And you'll see that this is going to be repeated when we talk about bills, medical bills. And here we go. God, I'm so good at transitions. This is going to be a great transition. I'm just going to let it sit for a second. So there's another type of expert that you're going to see used against you a lot, and that's medical billing experts. Medical billing experts. When I was a defense lawyer at Trotman Sanders, I hired a guy named Lamar Blunt. Worst decision I ever made. If you have a case with Lamar Blunt, I'm sorry. I was the first person to ever hire him in Georgia to do what he's doing all the time. I've actually had to cross-examine him live in November in a trial. Maybe the most fun I've ever had. But these are billing experts, and I use that very loosely. These are people who claim that doctors' bills and medical providers' bills are too high. Essentially, if you haven't seen this before, the short story of what they do is they take a look at all the bills and they compare the bills and the records to see if the records justify the bills. Might not make sense on its face, to some degree it does, but they're looking, do the bills match the records? So does everything that is billed, is that reflected in the records? And if it's not reflected in the records, then what they will say is, oh, well, this doesn't support the charge. The records doesn't support it. And Miss Cox is another, Tyler Watkins mentioned Miss Cox. She's another repeat offender. I had to post her a couple months ago. Send me an email. I'll send you the deposition transcript. She's special. So there's two ways that they throw out or try to tell the jury that the bills shouldn't count. They look at the record and say, oh, the record doesn't say that this happened, so then there can't be a bill for it. The second way is that they look at the actual bill and they say, oh, well, this bill is too high because either compared to this database that they made up, typically using sources like Medicare, Medicaid, VA, some of the PMIC, which is the provider manual. Compared to those databases, the bills seem to be above a certain percentile. So, for example, a charge is supposed to be, let's say supposed to be, a doctor bills somebody $10,000 for something, doesn't matter what it is. The medical billing expert will say, well, in Georgia, where I am, in Georgia, according to these databases, some of them are public, some of them aren't, the correct charge or the charge range is this. And because this doctor's charge is in the 80th, 85th, 90th percentile, whatever it is, that's too high. Logically, that means that whatever number they pick, if they say that 75% of above the 75% of the charge of what they say the reasonable charge is, they say it's above the 75th percentile, that's unreasonable. That means that 1/4 of all doctors' charge is unreasonable. Just think about how stupid that is. I'm going to tell you what I think are the 4 points you make to all of these experts, no matter what. So here are the 4 points that you make to these experts, no matter what. The first one is you ask this billing expert, are you saying that the client's medical provider committed fraud? Are you saying that the client's medical provider is committing fraud? I've yet to see one say yes. The second question you're going to ask is, the client owes the bills, right? So even if you say that the bills are 25% too high, the client owes 100% of the bills, right? Third thing you're going to say, did the client do anything wrong? By going to Dr. So-and-so, did the client do anything wrong? I've never heard anyone say the client did anything wrong. All right, here's my favorite question. It's the fourth question that you're going to want to ask. And I typically, this is my last question. You say, I'm talking to the expert, you say that Piedmont Hospital's bill is too high. Where else could my client have gone to get this same treatment for cheaper with the same expertise, with the same training, and with doctors of the same quality? Where? I've never heard an answer to that question either. So I've never heard answers that ever hurt me to, did the doctors commit fraud? Where else could the client have gotten the treatment? Does the client still owe the bills? And did the client do anything wrong? Those 4 questions I think you need to ask every so-called medical billing expert. I'm trying to think if there's anything else I wanted to mention about billing experts. I think that's it. Yeah, I mean, I think you do. I'm still looking at the comments. I think you do want to ask, how much those experts are getting paid. For example, Lamar Blunt in my last case got paid over $70,000 to say that bills are too high. And I think there's a good, compelling argument that the defense would rather pay somebody $50, $60, $70, $80,000 than pay the client's medical bills. I guess the thing that was crossing my mind before is this. I think it's important to tell the defense that if they're right, if the bills are too high, and if the client was taken advantage of by their doctor, where the client now owes bills that are too high, whatever that means, doesn't that just mean that the client has been victimized for a second time? The client gets hurt, no fault of his own. He's driving down the road, gets hit by this truck. The client now needs medical treatment. And the defense is now saying that the doctor essentially ripped them off, billed them too much. If that's the case, doesn't the jury then feel bad for the client? Doesn't that make the client a victim 2 times? Because the client owes the bills no matter what. The jury doesn't hear about reductions if there are any. On the other hand, the jury also doesn't hear about subrogation from health insurance, but that's another topic. So I tell defense lawyers that maybe they should consider twice about trying to make the client victim number 2, victimized again. So I think that's something that you might want to consider. AJ's going back to the applications, and he asked if I tender those into evidence during the trial. I didn't get that far in the one time that I've done it. Thinking out loud, I think if the client is cross-examined about it, I imagine I could admit them through the client. I think the better option may be, though, the defense in this case had an expert who said, that he wasn't really heard, even though the expert had never met the client, just based on records. I think that cross-examining the expert with, well, you say the client can work, here's 50-something applications, why couldn't he get a job? I think that's a fair question. So I don't know if it needs to come into evidence, but I think it's definitely cross-examination fodder for their expert. And honestly, I don't know if I want it into evidence. I don't know if I want the jury looking through, depending on the job type. I don't know if I want the jury looking through every job application and seeing that, my client who wants $1 million+ was a forklift operator at some point in his career. I don't know if I want the jury knowing that. All right, does anybody have any questions about the medical billing experts? It's one of my favorite topics, so I'm trying not to overdo it. It looks like Brett Moore made a comment. I think it's a really good comment about, he mentioned, is it reasonable to demand that people go around shopping for medical care when they've been seriously injured? Brett, I think the answer to that is no, and I think obviously that's your point, the rhetorical question. I'd be a little concerned though. I think that's maybe something you want to handle in jury selection, is bring up that idea. So I think that's a good jury question. If there's going to be, or jury selection question, if there's going to be an argument that your client's bills are too high, I think it's fair to ask, that in jury selection, and then ask that again, like you just said, to the billing expert. Should my client be shopping around? I think that's a pretty good idea. All right, the next thing you have are future medical treatment, or future medical bills and treatment. So again, you can use your client's treating provider to say the extent of the treatment that's going to be needed in the future, and to give most likely a ballpark price. If you are in a case though where the cost of bills and is contested, which, I mean, nowadays, I think that's most cases, ridiculously, you may want to go outside the treating provider, because you may want to insulate your treating provider so you're not asking him about his bills. You're just asking him in general, doctor, are your bills reasonable and was the treatment necessary? He says yes. Well, the doctors I deal with a lot of times are shielding themselves from defense questions of, well, you know, do you know this about your bill? Do you know this about the CPT code? Do you know this about the cost, and so on? And doctors say, generally, in my experience, they say, that's not me. I don't deal with that in my practice. That's my billing person. So if your doctor is either insulating himself, or you want him to, or you want a different person to give, you know, the future medicals, you can find an expert in that same practice area to evaluate your client, give a second opinion, and testify as to what future treatment is needed. In terms of cost, you know, you might want to consult a life care planner. You might want to consult someone who can price out how much those things are going to cost. Because even if the doctor is willing to say, yeah, you know, for a future hip replacement, let's say your client's 40 years old, gets a full hip replacement, that thing's going to last what, 15 years on a really good one? You know, a knee, 12 to 15 at best. So that 40-year-old is going to need additional substantial treatment. So what you can do is you can have the treating doctor testify that. If you ask the treating doctor how much does that cost, most likely the treating physician is only going to give you their fees, because the treating physician doesn't know, for the most part, doesn't know, and I don't think can testify to the fees for everybody else involved, the facility fee, unless the doctor owns the facility, but the facility fee, the PT afterwards for rehab, all those kind of things. So I think you want to consult a life care planner or a similar expert to be able to have the full cost. It also compartmentalizes your witnesses. You know, your treating doctor is there to talk about the treatment needs. The billing person, your life care planner, is there to talk about the bills and how much that's going to cost. So you're not asking witnesses to do too much, and it reduces your risk, because if the jury doesn't like one of those two people, well, at least they're excused by the fact that they're not trying to accomplish everything. Tim's asking, do I prefer the treating doctor to speak about the future treatment, or would I rather go to an outside expert? I think it depends. I have a case right now where, for a lot of reasons, some of them including I'm concerned about the treating doctor reaching too far on certain things. I'm concerned about a jury dynamic where I'm going to be in a county where I don't think the treating doctor will necessarily testify very well in front of those jurors. So I've decided to see if the client can go to a provider who I think the jury would rather hear from. And that's based on jury demographics. There's a lot of reasons to keep with the treating provider or not. I think that's a case-by-case basis, but those are some of the things I think you want to consider. And if the defense is coming really hard after your treating doctor, it might not be a bad idea to bring in a second doctor, because then they have to make a choice. Are they now going against two doctors? Are they now going to say two doctors are wrong? And I think that's the more people they're saying that are wrong, it's the harder sale. All right, let me look at my notes here. Does anybody have any questions about some of the experts right now? Anybody have any questions about some of the things we've covered? We've covered legal nurses. We've covered billing experts. Well, we've covered getting the extent of the injury from the treating physician, and we've covered future medicals. Jared, I'm getting to The Economist. You're so right. And I'll go to that right now. So I'm just reading the comments here. Kimberly, I'm not going to give a recommendation for a life care planner on here. I'll happily tell you some people that I've used. But I'm trying to stay away from shout outs other than from people that I really do trust. So, you know, y'all know, I guess from last week when I mentioned Case Metrics, I really do trust those folks. As opposed to, I don't have a specific life care planner. I also think that different life care planners and really different experts across the board should be used in different cases. You know, I think it looks bad if you've used the same expert on 50 cases over 2 years. So I think it's in your benefit to move around a little bit. All right, so Jared asked if I use an economist to value the loss of service when a permanent injury exists. So Jared, I'm gonna get directly to your question. I'm gonna back out for 1 second. I think you want to use an economist in general when the amount of money in the future is really high, because you want to convert that money into present day value. So, and also I think you want to spend another witness, even though it's going to be a quick witness. You don't want to put an economist up there for a long time. The jury's going to fall asleep. But it's another witness to talk about how expensive this injury has been to the client and how much money the client has lost. It gives you another opportunity to build up in the jury's mind and remind them of how much money has been lost. So yes, I think if there's a permanent injury and the medical bills and or the lost wages are substantial, I'm talking 6 figures. I honestly, it's probably a little higher than that for me. It's probably something like 250. And again, it's case by case, but in general terms, I'm thinking you do an economist. I guess you have a doctor. Let's say it's just for ease. Let's say it's your treating doctor, and your treating doctor says, going to need this treatment. You then have a life care planner price that out, and then you have an economist come in and convert that to present day value. So you've now have 3 experts talking about the financial harm the client has suffered, and it's coupling with the medical treatment and the injuries. So yeah, Richard's asking economist and life care planner. Hell yeah, why not? I mean, I think they serve 2 different functions. Technically, I mean, if the textbook answer is, a treating doctor is there for treatment and past, present, and future. Your life care planner is there to price out the future treatment, and then your economist is there to tell the jury exactly how much it's going to cost. Now, an economist is also useful to pair with a vocational expert, because your vocational expert's going to say, hopefully, if the circumstances warrant it, your vocational expert's going to say the client can't work, or that the client can only work in these limited jobs, and maybe there's a loss of income. Remember, though, it's not just about income, or it's not just about cash. It's not just about your paycheck. People that work for me, for example, they get paid. They also get health insurance. They also get retirement 401k planning. They also get PTO. They also get a lot of other things that have value. So what a vocational expert's going to do is going to tell you the things that are lost in terms of a job and also the home. If let's say if it's the husband, I'll use traditional gender roles. Everybody, excuse me. Well, let's say it's the husband who's injured, and typically he's doing cutting the grass outside. Well, that has a value because you're not hiring somebody to do it. So the vocational expert says, that part of this person's life is gone. So you got the job and you got the personal. And then an economist can come here and value all that and say, okay, this is how much it actually is going to cost now to have somebody else cut the grass. Here's how much it's going to cost for someone to do the dishes, to clean the house, to do all those things. So I think you're pairing an economist with a lot of things so long as you have high damages. Now, you don't need an economist. Economist is not a requirement. You can tell the jury, the life care planner says that this knee in the future is going to cost a combined $88,000. Give them $88,000. An economist can just go one step further. So if you're worried about the expertise of the life care planner, if you want to make sure that the jury has every I dotted and T crossed, then I think you're considering an economist. Jared, does that answer your question? Great. All right, in the last 20 minutes, I want to talk about some things to do during during a jury trial. So I'm going to start with the opening, and I could spend hours on this, and I might. I was actually thinking about running through a trial in one of these next webinars, but I'm going to walk through some things in the jury trial that I think you can do to increase and improve your damages right from the start. So one of the first things is jury selection. I mean, that is the first thing the jury is going to be involved in. And I think that you want to the extent that the judge lets you, you want to tell the jury that this is a significant injury case, that this case is a large case. And I think you can do that by saying this. And this is one of the few things that if this is new to you, I would suggest writing it down. Here's the line I think you need to say. So you're in jury selection, you're in your part where you're talking about damages. And I think you need to ask this. Even if the case supported it, would you not award X dollars? So, ladies and gentlemen, even if the evidence supported it, is there anyone here that would not award $1 million? Anybody? Anybody here that would not award $1 million even if the evidence supported it? Anybody? I think that's the question you need to ask, and your number may change depending on the case, but I think you need to ask that question. The response to any objection, by the way, is that you're not asking the jury to predetermine the case. You're not asking the jury to predetermine the case. You're asking the jury if they're going to follow the law. Because if the case warrants it and the evidence supports it, the jury should award $1 million. But if the jury is not going to do that when the circumstances say they should, then they're not following the law. I've only had one situation where a judge pushed back on me on that, and we were literally negotiating what number I could say. I wanted to say $5 million, and the judge said, well, I'll let you say $1 million. I said, well, if I can say $1 million, why can't I say $5 million? So I ended up killing that question. I didn't ask that question, and that still sticks with me. So I think you should be able to say that in almost every case. So now you get to your opening. I think that you tell the jury, ladies and gentlemen, this is a case where our client suffered these injuries, and you're going to go through some of the injuries in opening. And I think you tell them, at the end of the case, we're going to ask you for more than $1 million. And just let that sit in. Just let it sit there. Let that sit there. Also, let me go back in jury selection. When you say the question of, even if the evidence supported it, would you ever award $1 million? You and your entire team need to be looking at the faces of every juror. You need to be seeing who goes. You need to see who goes. You need to see every reaction. Because Scott Cohen says he started doing this, and he said he'd never had more jury strikes for cause. I think you need, though, to not just look at hands. You need to look at faces and reactions. Lewis mentioned here in the comments that it's very helpful to get the big numbers out early. Absolutely. I don't think you want to surprise the jury at the end of closing when you say to them, I want $1 million. Jury's going to go, oh, whoa, whoa. And then that's sinking in. You need to tell them early, often, and repeatedly how much money you want. So we've told the jury in jury selection how much money we think the case is worth. We've told them in openings. Now, I mentioned this about looking at the faces at the jurors. When I'm done with jury selection, when I'm done with openings, that's typically that's the first day or the first day and a half of the trial, depending on how long jury selection works and how quick the judge gets going. So what I'm doing on that first break before I call my first witness is this. I'm taking all of our notes for the jurors and I'm compiling them into one document. And I'm talking about the jurors that are on my jury panel. And I'm trying to figure out who is who. I want to know, and here's my general overview of jury selection and jurors. I think in general, there's three groups. There's the one group that no matter what you do, it could be their mother who is the plaintiff. They don't care. They want the heck out of it. The second group are the people that they're just there. They're not going to be disruptive. They're not going to go fight for anything, but they want to get it right, but it's not that concerning to them. The third thing are your leaders. So during jury selection, the only thing I'm trying to do is find out who the leaders are. And I'm trying to get rid of the leaders that I think are predisposed to be bad for me and keep as many leaders as I can that are going to be good. If I'm striking jurors, the ones I'm getting rid of are leaders that I don't know where they're going to lead, that I don't know enough about. So in this first break, whether it's the night after jury selection or right after openings, if I have to do jury selection openings on the same day, I am trying to figure out who my leaders are and who I'm going to entrust with information. Who I'm going to entrust with information. So from a damages perspective, I want to entrust to a juror, or maybe two, you're going to be my damages people. So maybe it's somebody who said in jury selection that if the evidence supported they would award $1 million, I asked them why, and their response was because the person is owed everything that they have a right to get if they're injured. For the rest of the trial, every time I talk about damages, every time there's a way for me to connect with a jury about damages or a juror, I'm looking right at that juror. And maybe when I'm asking the question to the billing expert, the defense billing expert, who's there to say the bills are too high, maybe when I ask the question of, well, expert, isn't it true that my client owes all of this money? Just because you say the bills are too high, that doesn't make it go away. I'm not even looking at the expert when I ask that question. I'm looking at the juror because I'm entrusting him with the information. So that way, when he goes back in the jury deliberation room at the end, he knows I'm the damages guy. I'm the guy that when damages pops up, I'm supposed to talk about that because Mike entrusted me with that. And I'm not shy about entrusting things with people. I'm looking directly at them, directly at them. Now, you're not allowed to talk to jurors generally by name, and you're not allowed to, there's a law that says you're not allowed to bring up what happened during jury selection. That second part, I think, is violated on a regular basis, to mostly by plaintiffs' lawyers to our benefit, but there's nothing wrong if there's no objection. So if you're saying, you know, hey, we have jurors here who have done this, this, and this, and you're bringing up things from jury selection, do it until you get caught and entrust those people with important information. So if I've got the person who had a back injury, anytime I talk about a back injury, I'm looking at that person, I'm talking directly to him. You know, I say to my client on the stand, tell me the worst part about having a back injury. As soon as I say that, I'm looking directly to my back injury juror. Looking right to him. That way that juror knows that, I mean, subconsciously, or maybe even the juror might be smart enough to realize, that juror knows that when they go back in the jury deliberation room, when they talk about back injuries, that's that juror's time to shine. I want everybody to have a purpose. So I get into witnesses. I'm going to, just in a general motor vehicle crash, my first witness is typically, let's say it's a commercial motor vehicle. My first witness is typically the company's 30B6 witness, followed by the driver, or maybe a security person or a safety person, one of the two. So what I've done is, what I'm doing is I'm letting the defense tell their story. This is the defense strategy. And then I'm going to disprove that. I'm going to call neutral witnesses, police officers, eyewitnesses, other drivers involved. I'm then going to call medical doctors to talk about my client's injuries. I'm then going to call, typically, my client, and then I'm going to end with before and after witnesses. Generally speaking, the reason I do this is I present the defendant's case. I prove why it's wrong using neutral witnesses. So the defense says, I didn't cause the crash. Cop says, the defense caused the crash. Eyewitness says, yeah, the defendant driver caused the crash. I've already proven that. I then go into damages. My doctors, medical providers, life care planners, economists, whoever, they all prove the injuries to my client. I then have my client, I'm going too low. I then have my client testify, and all my client has to do is be nice, likable, tell a consistent story about the crash, and touch on his injuries. And then the before and after witnesses talk about the human life effects. You notice in that my client is doing the least amount of work. My client is doing the least amount of work. not putting the onus and the burden on my client to carry the case. Before and after witnesses, I think, are essential to a large verdict. I think you would need at least 3 before and after witnesses. You need a friend, a family member, and somebody else, coworker, friend on a sports team. You need somebody else. So I think in all circumstances, you need those 3 people. Once you have those 3 people, you're hitting all walks of life, and you're talking about the human damages. Now, I talked last time, and if you didn't get the materials from last time, I'm going to send them again this time, about our personal reference form, that we get the names and information for damaged witnesses very, very early. I'm calling them damaged witnesses. They're before and after witnesses. Their goal or their purpose is to testify about what your client was like before and what your client's like after. I don't prepare these people in the normal sense of, here's what I'm going to ask you. I'm asking them to tell me stories. I think it's really important for these before and after witnesses that it be natural and not scripted. So the first question typically I ask the before and after witness when they take the stand is, do you know what I'm going to ask you? And they say no, because they don't know. Now, certainly they have general ideas. They've told me stories, but they don't know. I think it's extremely important to be real with the jury, not be scripted, not for it to be a TV show, not for it to be a play. So I think that you can be prepared without being scripted, and I think that's very important. Excuse me. The same goes for your client. In terms of damages, I don't think that it's worth over preparing your client. I think that when you think of preparation for a case, and especially for direct testimony of a witness or of your client, I think you need to think about it from the perspective of, what do I need to know about stories and how can I expand on them? So I had a case where a client told me that he had been paying for his mom's rent his whole life, and then when he lost his job because he was injured, he couldn't do that any longer. In that circumstance, the client told me that like a year before the trial, and I never brought it up to him until trial. So you need to be a historian of your client. Now, when you get to trial, I've spent my whole time today talking, and I apologize, I haven't shared enough. I want to show you some things that I share at trial, and some things that I think make a really big difference. So when you have a client who is a really good client, they're going to have good friends and family. And for those people that you talk to, their friends, their family, and loved ones, you want to ask them, what did so-and-so like to do and what can't they do anymore? They tell you, for example, the client's a runner. The client can't run anymore. Really, how often did the client run? Well, she was part of the Atlanta track club. Oh, okay. Do you ever do anything for her? Ever go cheer on? Yeah, I did. And guess what? I made her this poster. The friend's daughter actually made it. So that poster, we took a picture of it just so we could send it to the defense, but that poster, I think, tells more than our client talking about how she can't run. We also got our client, whose name is Maria, and she's awesome. Get this. Also, come on screen. Huh. I'm going to try this over here. Bear with me here. First technical snafu on Zoom. There we go. We also got Maria to go home at some point and find some pictures of her. And these are all of her medals from running. Maria's an incredible lady. She's a lot older than you think, and she's a far better runner than probably all of us. So right there, rather than Maria saying, I'm a runner, people cared about me, we've shown it. And we've done that through damages witnesses. Everybody talks about Facebook and about social media. Oh, I don't want my client on Facebook. I don't want my client on social media, and so. Well, I do think that you want your client to not say stupid things on Facebook and social media, but that doesn't mean you don't want your client on social media at all, because, oops, there's Maria again. Because when the client says things that are positive I think you want to make sure that you get those. So can you all see this Instagram post? This is after an injection, a steroid injection. Gina is our client's wife, and Gina wrote this post. That's a good post. That's a good post. So make sure you're asking friends, family, loved ones, and your client for all of the information that you could possibly show. This was from January 2015. This case went on for a very long time. This is January 2015. They didn't have a lawyer at that point, and they didn't know that they should or shouldn't be posting. So use it to your advantage. I think it conveys significance if they're telling the whole world, the client and his family's telling the whole world, he's in so much pain. All right, the last thing I want to talk to you about is the ask. So last week I went through a little diatribe about how I think multiples are bullshit. So saying 3 times the medicals is the amount of pain and suffering has no reality, at least has no basis in reality or function. It's stupid. So with that said, I was thinking I probably need to give you other ways in order to build up damages and how to ask for them. Because if you're not going to just say, oh, this is how much, well, then, I don't want to leave you all hanging. So the first idea I want to give you is probably been used for years and years. It is the so-called wanted ad. It's the so-called wanted ad. So here is, and this isn't a great wanted ad. I couldn't find one that I wouldn't be violating, I think, some sort of trust or not necessarily a privilege, but maybe some sort of trust. So I'm just using this. This is the wanted ad. The idea here, and you see the case site under Harvey versus Williams. It's brand new. If you're going to use the wanted ad, make sure you consult this case because there's brand new clarification on this rule. But generally, the idea is you make the client's injury and situation a job. So if the client has a cervical disc replacement and can't move his neck and has all those things that go with it, you are going to say, ladies and gentlemen of the jury, I want you to consider this wanted ad. And when I say a wanted ad, you should have one. You should literally have a wanted ad. And it should list wanted, person that meets these specifications, and here they are. Somebody who was in a car crash, someone who went to the emergency room right away, someone who had to call their family from the emergency room and scare his wife and say, I'm in the emergency room and I need help. Can you please come here? Somebody who goes through all the medical treatment, someone who loses their job, somebody who, and you got to list everything here. And the idea here is how much is that job worth? How much is that job worth? Now, make sure you look at Harvey and Williams to see the exact language you need to use. The exact language you need to use. Don't get a mistrial. Because there's the golden rule where you can't say to the jury, put yourself in this position, but you can use hypothetical language. You can use hypothetical language. So again, disclaimer, look at Harvey versus Williams. It's a really important case, especially if you're gonna use the wanted ad. So you have the wanted ad. Now, how do you figure out how much? You got focus groups. You've got common sense. You also can, I don't know, buy a 6-pack of beers and have some of them, and then ask your friends, hey, how much would it cost for me to rip out a disc from your neck and put in one? How much would that cost? How much would you take? There is no great answer. I think, though, that the key to asking for money in front of a jury is confidence. It's absolute confidence. And the way that you're going to get the confidence is not by faking it. It's by being the expert in the courtroom. One of the first things that I do when I get to a courtroom when I'm having a trial is I learn everyone's name. Hopefully you know the judge's name. Hopefully you know the clerk's name. I want to know the court reporter's name, bailiff's name, not just the bailiff in the room. I want to ask him, hey, who else comes in this room? I want to know every bailiff's name. If there's a public defender that's going to be in there, in the mornings, maybe doing some criminal stuff. I want to know that person's name. Anybody that goes through that courtroom, I want to know first and last name. And when I talk about what's going on, it's my courtroom. When I'm in opening and I'm explaining what's going to happen, well, Miss Teresa over here is going to write down everything that we say. You see Deputy Jones here. If you have a problem, you go to Deputy Jones. I'm the leader. I'm the boss. It's my courtroom. With all respect to judges who maybe will listen to this or this will be shared with them, at a jury trial, the judge is the least important person in the entire room. The judge is the least important person in the entire room. I don't want the jury looking to the judge. Is it okay if this happens? I want the jury looking to me and saying, Mike, is that okay? Can they do that? And if you are the expert and the jury believes you're the expert, then why should you have any fear about saying a large number? Why should you have any fear about saying a large number? How else do you build up credibility and expertise? You're honest about what you don't know. Every single jury trial I've had, I've told the jury something like this. I envy you, jurors, because you get to make the decision here. And you get to right or wrong, whatever that line of thought is. But at the same time, you all have a tough job. Because when it comes to how much to award here, I don't know the right answer. Nobody does. And anyone that tells you the right answer and says they know it, they're lying to you. There is no perfect answer to how you compute damages and what number you should give. I trust you to do the right thing for my client. I'm going to tell you some ways, though, that you can consider damages and ways that you may want to use in order to get to your number. First one's the wanted post, okay? So you've built credibility by saying that you don't know everything, because somebody who knows everything doesn't know anything. All right, another way that you can do damages and tell the jury a computation is the per diem. Per diem is just how much per day, per hour, per week, per month, per year, whatever, the jury would need to award in that situation. So you can say to the jury, you should, right off the top, give my client their $200,000 in medical bills, without a doubt. Got to give them your medicals. But now the question is, how much do they get for the past pain and suffering, and how much do they get for the future? Well, the past pain and suffering might be a different value than the future. I'm okay with that. I'm okay with two different values. Once you start getting into 3, 4, 5 different values, it gets tougher. If you're asking the jury to do this many days multiplied by this number, this many days multiplied by this number, this many days multiplied by this number, and then add them all together, that's not going to happen. So I'm okay with two different per diems, usually a per diem until they got treatment and felt better, even if it wasn't all the way, and then a per diem for these are the effects for the rest of the life, or these are the effects until this. Generally, you want to make your per diem as low as possible. So maybe it's a per day per diem instead of a per week, because then you can ask for $10 a day instead of $70 per week. $10 a day sounds a little better. I mean, that's Starbucks and or that's a McDonald's meal. So I think the lower per diem is better, and I think that is easy. Make sure you do the math for the jurors in front of them. You can actually do it on a whiteboard. You can just tell them the number. You can just tell them the number. In my experience, this case is worth $1 million. What I find is helpful and persuasive when you're just going to tell the jury the number without using a mathematical computation is to also tell them one other thing. Say, this case is worth $1 million. But ladies and gentlemen, it's not worth $2 million, and it's certainly not worth less than $750,000. So here's what I'll tell you. Do not award more than $2 million. Don't do it. My client thinks their case is worth $1 billion, and they have every right to do that. They're the one that's injured. They're the ones that's lived through this. I don't blame them. But their case isn't worth $1 billion. In fact, their case isn't worth more than $2 million. So under no circumstances do you award more than $2 million. But the case also isn't worth less than $750,000. So I'm telling you, ladies and gentlemen, you award $1 million when you've done right. But don't go above 2, and certainly don't go below $750,000. Again, you're gaining credibility because now you've taken away the idea that that the jury's thinking, oh, well, he wants all the money in the world. No. I want a fair amount. I want a fair amount. And that fair amount is not less than this and not above this. I like that better than ranges. A lot of people say you should award more than, or you should award between $1 and $2 million. Yeah, I like saying do not do this and do not do this. I've created the same range. Tyler, and when I say in my experience, I think I typically get away with that. At my last trial, I said, I was in Clayton County, and I said something about the $1 billion verdict that Chris Stewart got, the uncollectible $1 billion. That was certainly too far. Again, no objection. But I think in my experience, I think you're okay to say that. If you're going to have an objection to that, I'll eat that. I'm okay with it. I mean, there's certainly probably more eloquent ways to say it, based on the injuries in this case and based on the facts. There's not a doubt in my mind that this case, the value is $1 million, but at the same time, the case isn't worth $2 million. So now I've created that range without explicitly asking for it. I did this in a trial where I asked for $1.5 million. And I said, under no circumstances do you award more than $2.5 million. But no matter what, it has to be a 7-figure number. So it has to be a 7-figure number. It should be 1.5, but don't give me above 2.5 because the case isn't worth it. I got 1.75. You don't hear about people getting above their ask often. And I think the reason is because when you ask the jury to do it, they don't feel the same worth and they don't feel the same accomplishment. If I tell them it's worth 1.5 and they're going to give me 1.75, they're feeling really good and they want to take credit for it. So let them take credit. Let them do that. All right, people. I've given you some thoughts here. What I want to do is leave you with this. Have no fear. Have no fear. No matter who is on the other side, no matter who the defense expert is, no matter who the defense lawyer is, they're not better than you. They don't know the case as well as you. They're not as creative as you. Who cares how many years they've been a lawyer? Who cares how many cases they've tried? It doesn't matter. When you walk into that courtroom, when you walk into the deposition, when you're thinking about your case, have no fear. If you have fear and if you're worried and if you're not confident, I think that means you're not prepared enough. Because if you know every detail of your case and you've thought everything through, you're going to be confident. You might be a little nervous. Sure, you might be a little nervous, but you need to be confident. You are the expert when you walk into every deposition. One of the first things I learned when I started taking depositions were the nonsense instructions that everybody says. I don't say them anymore, but the nonsense instructions that everybody says when you sit down. This is a deposition of so-and-so. It's taken pursuant to notice and agreement of the party. I would say that so many times before my depositions, because when I walked in the room, I wanted the other side to know I was an expert. I wanted them to think I do this every single day. I don't get into a trial or a courtroom for trials as much as I like. When you handle the kind of cases that I handle, for better or worse, the money is usually so high, or at least significant enough that it's life-changing money for people. And it's really hard to tell a client, even though I think a case is worth $1 million, it's hard to tell the client to risk $800,000 to get $200,000. There are circumstances when they should, but there are a lot when they shouldn't. So we try somewhere around 4 or 5 cases a year, and I think that's a lot, which is crazy. So almost every defense lawyer, I am not that old, almost every defense lawyer has more trials than me. Does not matter. When I walk in there, I am the expert. I'm going to show the jury I'm the expert, and I'm going to have no fear. Having no fear when you walk into a room is incredible. It's an incredible feeling. My last trial, I was deposing a defense expert who claimed that the MRIs did not show any significant injuries. So I laid down on the middle of the floor in the courtroom and said, "Doctor, is this how you take an MRI?" Put my arms next to me. "Is this how you take an MRI?" I said, "Yeah." I said, "Is this how you live life?" And he said, "What do you mean?" "I'm on the ground talking up to the ceiling. Jury's standing up looking at me." "Is this how you live your life? Laying down on the ground?" He goes, "No." And I said, "Is this how you Take care of your kids. Is this how you make food? Is this how you go to work? He's saying, no, no, no. Did I look stupid? Hell yeah. Looked like an idiot. Would I do it again? Yes. Was I worried though? About those things at the time? No, no. You can't have any fear when you do this work, okay? If you guys think about your cases, if you really focus on them and you really tune into what is important, I think you shouldn't have any fear. You are the best lawyer in every case that you have. If you know the most, you all are incredibly creative. So what I think you can do is you start building your list of all the ways that work and all the ways that don't, okay? And to that end, what I'm gonna do next week is a showing of good faith. Next week's webinar is going to be all the marketing ways that I've tried and failed, okay? Maybe the next week after that, I might do all the ways that I've tried in cases that have failed. But next week, we haven't talked about marketing. I'm gonna do all the things that I've tried and all the ways that have failed miserably, all the money I spent that hasn't worked, all the time I've spent that hasn't worked. But no matter what, I wanna leave you with the thought that you all are smart, incredible folks, that if you do the work right, you will be the expert in the room, and that if you are the expert, the jury will believe you. The best way to increase damages is to be credible and keep your credibility, okay? So with that said, thank you so much for joining me. I really, really appreciate it.